Mr. Singh, just before you start, I'm going to trouble you all. Bit of homework we did over the weekend on foreign language versions of Kluge. They don't always say the same thing in that paragraph about is the word relevant. You may want to, and we would benefit from your review of the relevant foreign language versions. We think the judgment was in German, but the Advocate General was in Italian. But you can look at the French, Spanish, anything. They don't always convey the same broad meaning. They're using different terminology. So, overnight homework, please.
I've got one more bit of overnight homework, if I may just add. I was just checking my bundle of authorities, and I think what isn't in here, and I'm not criticising for a second, but is Reed Personnel, the old 1995 decision of Mr. Justice Laws. And I've just looked at it over lunchtime, and I think I recollect rightly that in that case HMRC was running something very close to the argument that's now being run by the appellant, to say that nursing services provided by an agent, in that case, to a hospital, were in and of themselves exempt medical services, and that was rejected as a matter of domestic law. So I think we probably ought to just have that in front of us and invite your submissions on it.
I don't have any homework.
But he'll have thought of some by 4:15. Mr. Singh.
Thank you, my lords, my lady. So I appear with Ms. Newstead-Taylor, who appeared as sole counsel below in the first tier tribunal and the upper tribunal, and in fact succeeded on behalf of HMRC twice. So I hope I'm not going to be too much of a hindrance to in this appeal. Now, my lords, my lady, my key point really is that the facts here are very important. The facts found by the first tier tribunal. And we say on the basis of those facts, the medical professionals supplied by the appellant were used by the NHS Trust to supply medical care to patients in hospitals. And the services of those medical professionals were part and parcel of the Trust's supply of care to those patients. We say that there was no supply of medical care by the appellant itself, only a supply of medical professionals to A&E and then on to the trusts, which enabled the trust to supply medical care. And all of those submissions are based on the findings of fact made by the first tier tribunal. And what we do is instead of taking you through all the various 100 or so paragraphs, we've listed the key ones in our skeleton argument. So if you could just turn up page 148 of the core bundle. And that is paragraph 18. I just wanted to highlight some of these. So paragraph 18A, in the period between March 2010 and April 2013, it was likely on the evidence that direction, supervision and control of the consultants supplied by the appellant to A&E passed from A&E to the NHS Trust. B, in the period between April 2013 and January 2014, in practice a consultant would have to cooperate with requests made by the NHS Trust to the extent reasonably required to enable the NHS Trust to progress its work requirement. D, the only way in which the appellant could comply with its obligations under clause 2.1 of the A&E agreement, which required compliance with, for example, all the NHS Trust's reasonable requirements and regulations and so on, was to require the consultants to comply with them. E, it was a matter for the NHS Trust as to which part of the hospital the consultant was required to work in, and the hours the consultant was to work under their agreement with the appellant were clearly intended to mirror the terms in the assignment schedule in the A&E agreement, and presumably A&E's agreement with the NHS Trust. Now, the reason the word presumably was used was because the first tier tribunal didn't actually have any of the contracts between A&E and the Trust. So we are assuming really that it would have been the same thing that was onward supplied to the NHS Trust. And then if we just skip over the paragraphs dealing with the evidence, H, the the FTT noted that both Dr. Bailey and Dr. Berry, who gave evidence, accepted that their clinical decisions might be subject to local policy of the NHS Trust. For example, in relation to prescribing extraordinary drugs, it was significant they both accepted they were required to take clinical decisions within the remit of the Trust policies. And then based on the evidence as a whole throughout the relevant period, consultants were under the control, direction and supervision of the NHS Trust and operated within the framework of the NHS Trust. They effectively became part and parcel of the organisations of the NHS Trust, which were themselves providing medical care to patients. And then finally, J, the consultants engaged by the appellant carried out their work within the framework of the NHS Trust, in the sense that they operated within the remit of the local policies it laid down and were incorporated into the organisation of the NHS Trust in the same way as a consultant who might have been employed directly by the NHS Trust. And when the upper tribunal looked at this point, it commented that the NHS Trusts appear to have exercised the same degree of control over the consultants and specialist GPs. We don't really know much about what the specialist GPs did, so we put them to one side for the moment, as it did over the consultants which it employed. So what we say is that those findings are wholly supportive of our case, that of the appellant's supply of medical professionals being consumed by the trust to make its, as in the trust's, supply of medical care. And as we say at paragraph 19 of our skeleton argument, all the above findings support the proposition that the NHS Trust procured consultants in order to make its own supply of medical care to its patients. That is why the NHS Trust exercised the same degree of control over the consultants supplied by the appellant as it did over the consultants which it employed. After all, both were part of the means by which the NHS Trust provided medical care to its hospital patients. So our point is that consultants supplied by the appellant were not acting independently of the trusts. Now, that's just kind of one half of the findings of fact. What we also do in our skeleton argument is that, as well as listing the findings of fact which we say support our case that the appellant's consultants were used by the trust as a means of supplying the trust's care to its patients, we also list the findings of fact that point away from there being a supply of medical care by the appellant. And I would just ask you to briefly look at those. They are set out at paragraph 23 of our skeleton argument. And you'll see that at A, in its guide provided to consultants, by the way, you have all these documents in the supplementary bundle in case you want to look at them. In its guide it provided to consultants, the appellant described itself as specialising in providing temporary workers, contractors to recruitment agencies and end clients, and as operating a high quality and tax efficient payroll structure. So my learned friend said, well, I would only describe them as a payroll company, but that is really how they describe themselves in the guide that was provided to consultants. And then B, in the employee handbook it provided to consultants, it described itself as providing suitably qualified personnel to recruitment agency, which the agency then places with end clients. C, it did not check that the consultant was suitably qualified to provide medical care. Now, there was a question about professional indemnity insurance, but there were findings about that by the first tier tribunal, and that's at D. There was no evidence that the appellant arranged professional indemnity insurance for consultants, nor that it obtained its own professional indemnity insurance. E, it would not know the consultant's specific working patterns, either in terms of where in a hospital they were working or what hours they were actually working on any specific day. F, no evidence of any contact between the appellant and consultants, save in relation to payroll matters. G, no evidence of any contact between the appellant and NHS Trust. And finally, H, the perception of consultants would have been that the appellant was simply providing a tax-efficient payroll function in relation to assignments negotiated between the consultants, A&E, and the NHS Trusts. And there are other points that could be made, such as there is no indication of any difference in how the consultants supplied by the appellant and the consultants employed by the trust worked in a hospital. And picking up on the kind of clinical negligence point that was raised, let's just look at this from the perspective of the patient. They are simply receiving care from the hospital. It would make no difference to them whether their treating consultant was employed by the trust or employed by the appellant. Now, Malone and Friend seem to agree that it would be the trust that the patient would ultimately look to if anything went wrong, any clinical negligence, because the trust is supplying their care. Then there was a debate about whether the trust would look to the appellant to indemnify it. And I say that the trust would not look to the appellant to do that because the appellant is not supplying it with any medical care. The appellant is further back in the contractual chain and it is supplying qualified people to A&E, and the trust is then contracting with A&E to use those people to itself provide medical care. I would say it's very far-fetched to suggest that the NHS Trust would look to a payroll company some way back in the contractual chain to indemnify it for any medical negligence. And we do say it really was on the facts, as summarised in our skeleton argument, that the appellant lost. That the facts were why the first tier tribunal found that it was not supplying medical care, and it's also why the upper tribunal upheld the first tier tribunal's findings. And when we come to the law, so once we have the facts, on the facts, the appellant supply is not exempt under the provision we're looking at, Article 132 1C, and the corresponding provision in domestic law, item 1A, because the appellant is not supplying medical care by a consultant. It's supplying only the consultant, who then is used, and I know I'm repeating myself now, but who's then used by the trust to make the trust supply of medical care. And we do just have to note the precise language used in both the Principal VAT Directive and in the domestic provision. So Article 1321C, it exempts the provision of medical care in the exercise of the medical professions. And item 1A exempts the supply of services consisting in the provision of medical care by a qualified person. Now, the appellant provides the consultant. The consultant has the potential to provide medical care, and the consultant goes on to provide medical care on behalf of the trust. But what we say is that the consultant's activities cannot be attributed to the appellant to render the appellant's supply a supply of medical care. And just on that point, the appellant did suggest below that they could and should be, because the consultants were not independent of the appellant. And Malone and Friend relied on Article 10 of the Principal VAT Directive to make that point. Now, it's just important to note that the upper tribunal rejected that argument, and it forms no part of the appellant's grounds of appeal to this court. And it may be useful just to turn to the upper tribunal's decision to see how the point was argued and why it was rejected. So if I could just ask you to go to page 32 of the core bundle. And you have paragraph 9 set out at page 32, which sets out Article 10. Article 10 of the directive provides the condition in Article 9.1 that the economic activity be conducted independently shall exclude employed and other persons from VAT insofar as they are bound to an employer by contract of employment, etc. So that's what it says. So the idea is that you shouldn't treat an employer and an employee as kind of making separate supplies and then tax both of them. That's kind of one of the features behind it. And then we can see how Malone and Friend relied on it. If we go to the decision and I'll just get the right, so if you go to paragraph 76, which is page 46 of the core bundle, paragraph 6 states, Mainpay argues that the first tier tribunal erred in drawing a tripartite distinction on the matter of control over clinical decisions. The appellant said the consultants exercise control, and then it said the consultants were not carrying on a separate economic activity, and their activities failed to be treated as part of Mainpay's economic activity in accordance with Article 10. Mainpay contends that if the consultants were the ones exercising control over their clinical decision making and their economic activity, which logically included the exercising of that control, forms part of MainPay's economic activity, then MainPay's economic activity does involve exercising control over the clinical decision making. And then if you could go to paragraph 94, about 6 or 7 lines down, it states, Mr. Firth submitted that only the medical practitioners had control over their clinical decision making, and this was a relevant control for these purposes. Moreover, that control could be attributed to MainPay by virtue of Article 10 of the directive. And then if we see how the upper tribunal treated the argument, well, I suppose there's another example of the argument at paragraph 116, page 56. And at paragraph 116 it states, Mr. Firth also argued that if the medical practitioners exercise control over clinical decision making, then Article 10 of the directive had the effect that the activities of those practitioners were attributed to the economic activity of MainPay. This had the result that MainPay did not supply control of the medical practitioners, but supplied clinical decision making. And then the tribunal's finding, 117, was we have no hesitation in rejecting this argument. Article 10 is intended to prevent the activities of employees constituting an independent economic activity for the purposes of Article 9. Whilst it's true that the activities of the employee are treated as part of the economic activities of the employer for that purposes, so that supplies made by the employee in the course of the employment are treated as supplies made by the employer, that does not mean that every characteristic or attribute of the employee is thereby deemed to belong to the employer. In this case, as a matter of economic and commercial reality, it is impossible to say that MainPay, an entity which had no medical qualification nor any medical expertise or knowledge, exercise any degree of control over the clinical decision making undertaken by the medical practitioners, and Article 10 does not deem it to do so. And just again, that matter is not before you because there was no ground of appeal challenging the upper tribunal's conclusion on Article 10. And the other matter that is not before you, and I think my learned friend has recognised this, is that the appellant did not seek and does not have permission to appeal on Article 1321B, which is the other limb. And just finally, the appellant did not seek and does not have permission to appeal in respect of Item 4 of our domestic legislation, which relates to Article 132(1)(b). But in any event, my learned friend agreed with my Lord Justice Green that Item 4 was academically interesting but irrelevant. So that's what we can put all of that to one side. Our focus is on Article 1321C and the corresponding provision in our domestic law, which is Item 1A. And my learned friend spent some time on the authorities and on the various principles. Now, I suppose my headline point in response is that because the factual position in this case is that the supply of medical care was by the trust and not the appellant, we say that that's an inference that inevitably arises from the facts. The authorities that my learned friend is taking you to and general principles such as purposive interpretation and fiscal neutrality cannot assist the appellant. But what I'm going to do is, I think I'll be shortchanging my clients if I just sat down now. So I'm going to nevertheless...
We might have a few questions.
Yes, exactly. And I'll be shortchanging you as well. So what I'll do is I'll go through the decisions my learned friend relies on, and I'll make submissions to why they do not help the appellant. So the first case he took you to was Kugler, and this is an important feature about many of these cases. Just bear in mind that the facts of all these cases are very important, and the fact in Kugler was that the company did supply medical care. So it supplied home nursing, and if you want the reference for that, that is in A.G. Tisano's opinion, which is, so the tab number is tab 19 of the authorities bundle, it's page 261, and it's paragraph 9. And from the Court of Justice's judgment at page 309, we see the Court of Justice saying that the nursing was provided by qualified nursing staff. So we have the medical care as the kind of basic feature here. And then what my learned friend did was that he relied on Kugler, particularly... Sorry, my lord, I think you were about to ask me something.
I thought about it, then I thought I won't, but since you've now invited me.
Yes.
In both cases, I mean, both of your analysis, in a company law sense, the company provides a service. You are now looking at the substantive economic activity of the company itself, and you're saying that it provided home nursing. That was its core economic activity.
Yes, that's what the company did.
But in a sense, we are lifting the corporate veil a bit to look at, in a purely traditional Gower and company law sense,
Yes.
the economic activity of employees is attributable to the company. That's
Yeah,
just, there's no magic about it.
No, so that's why the legal form point was relevant in Kugler.
Yeah.
So the company in Kugler did not only supply nursing care, it also supplied other things, such as kind of domestic help, that type of thing, which were not considered to amount to medical care. But the key point is that the company, through the employees, of course, supplied medical care. And then my learned friend took you to that paragraph in Kugler from the judgment, paragraph 27.
Yeah.
And the first point made there by the Court of Justice is that Article 132(1)(c) does not require medical services to be supplied by a taxable person in Sorry, Lord, do you want me to take you back to it?
No, I've got it here. Yeah.
Yes. So so he took you to it, and it said that paragraph said that 132(1)(c) does not require medical services to be supplied by a taxable person endowed with a particular legal form in order for them to be exempt. So that goes to, it doesn't have to be a natural person, it can be a company.
Yeah. Yes.
But he was also relying heavily on the two conditions that the Court of Justice said had to be met. So medical services must be involved. That's the first word.
That's the word we were troubled about, involved.
Yes, that's a word which we'll try to help you on overnight. But let's just take that let's say we've got the word involved. Let's not go behind that for the time being. That's the first condition. And the second condition is that the medical services must be supplied by persons who possess the necessary professional qualifications. Now, we agree with all of that. We're not trying to say that that's wrong or anything like that. We can't. It wouldn't be very sensible. It's a Court of Justice decision. And in this case, medical services were involved, and they were provided by people with the necessary professional qualifications. But importantly, that does not tell us who was making the supply of medical care. And what we have to do is we have to return to the FTT's findings of fact for the answer to that question, in my submission. And the answer is that it was the NHS Trust. So we say that they're the ones making that relevant supply. So then when we get on to Malone...
Your distinction is it's the difference between the supply of a consultant and the provision of care at the point of provision in the NHS.
Yes, exactly.
The latter is what you do, the former is what MainPay do.
Yes, exactly. I mean, my learned friend, he uses what he describes as a neutral phrase in his skeleton argument of doctors' services. He says it's not controversial that everyone here is supplying doctor services. That is controversial, because we're saying that that implies that it's medical care being supplied by the appellant, whereas we say no, it's not. The appellant is just supplying the qualified human, essentially, and that qualified human is then being used by the NHS Trust to deliver the NHS Trust's supply of its care. So we don't accept that any medical care, medical service is being supplied by the appellant. And this is why, my lords and my lady, it's no answer for my learned friend to then take you to these cases in which it's clear that the directive does not exclude upstream supplies of medical care. I mean, that's the important point. When we look at all of these cases, there's always actually a supply of medical care, and I'll come on to look at them in a moment. But our point is that the appellant is not supplying medical care. There's only ever a supply of these consultants. Of course, the consultants have the potential to provide medical care, but no supply of medical care is in fact made until the trust uses the consultants. And
I think, Mr. Singh, we need to pick away at that, because I think, as I understood it by the time just before lunch as we got to it. As I understood the argument, it was that if you look at the case law properly and you construe Article 1321C properly, the supply of medical care is broad enough to encompass supplying people who provide medical care. In other words, the supply of staff or the supply of doctors is a form of supply of medical care, and the whole argument sort of collapses in on itself.
Yes,
So we just need to understand that, don't
yes, so milady, we say that is not the position that emerges from the authorities. And if I can just go through the cases that my learned friend relied on that kind of point. So the first case, I think...
Before we leave Kugler,
Yes.
I understand your point, but what the company did in Kugler was provide nursing care.
Yes.
The way it did that was it provided nurses who provided care to the individuals who needed nursing care.
Yes, it provided nurse. Yeah, one of its services was to provide
It
nurses.
employed nurses.
Yes.
Kugler employed nurses, sent
Yes.
them to people's homes,
Yes.
and they provided nursing care to
Yes.
the individual patients.
Yes.
What is the relevant distinction between Kugler employing nurses, sending them to people's homes where they actually nurse the patients, and MainPay providing doctors, send them to NHS trusts where they provide doctor's services to patients? What is the line between the two? Because it's quite clear from your submissions that they are different analyses, but I haven't quite understood what the difference consists of.
Kugler didn't send the nurses away to be used as part of someone else's supply of care. That's a key difference. What was happening here was that the appellant was supplying the consultants to A&E. The consultants were then being used by the trust to deliver the trust's own supply of care, whereas that wasn't going on in Kugler. So the company was supplying care. Its supply wasn't being used the relevant supply of care on the facts was not by someone else. It was by Kugler. That's the distinction, my lord.
So is it?
Well, it was the nurses who were actually physically redressing the bandages.
Yes.
But your point is they weren't working for another organisation. They weren't being supplied to another organisation to dress bandages. It was Kugler's responsibility.
Yes. So you have to look at all the facts. You have to look at things like who actually has kind of
Degree of
direction
integration.
over. Yes. Things like direction. Who's directing what in that case the nurses were doing? Who would be directing what the consultants are doing? You look at all those factors, and then you ultimately decide, well, who is actually making the supply of medical care here? And we would say, in our case, it is not the appellant. That's the distinction. So the services are not being consumed. So the services in Kugler, the services were medical care. So Kugler was supplying medical care. Here we have a supply of people, which is being used by someone else to supply medical
Is that the crucial distinction? That in Kugler there's no other organisation. It's just Kugler and the nurses and the patients.
But I would also say that in Kugler there is the underlying supply of medical care. I do say that, my lord. I say Kugler.
Well, I understand that's
yes.
what you're saying, but I'm trying to understand why you say Kugler's supplying medical care. Kugler's a company.
Yes.
It's the nurses in people's homes who are actually doing the care.
Yes.
Why is Kugler supplying the care through its nurses, but MainPay not supplying the care through its doctors? And I think your answer is
yes,
because what MainPay is doing is making the doctors available to the NHS Trust, and it's the NHS Trust which is responsible for the clinical services the doctors are actually providing.
yes.
Is that your answer?
That is what I'm saying. But my lord, there is another point, which is the appellant services on the facts are not comparable to the services of, say, Kugler. The appellant, I'll come on to make the submission, doesn't have even a capacity to provide any medical care. We'll come on to one of the cases where
This is the company. It does through its employees. We absolutely understand that above the employees, you've got a payroll service.
Yes.
We see that, but it's in one sense it rather begs the question: is it if it's got all these employees, whatever the basis, however short term, they do provide a medical service. I think your point is that, as my lord puts it, when they go into the NHS, they're as it were folded into the NHS service. And it's a question of degree. You say on the fact findings at that stage, that's when the care starts.
Yeah. Well, yes.
On the facts, because of the degree of integration and control and supervision.
So the consultants are not, obviously as a matter of fact, the consultants are providing care, to people in the hospital.
Yeah.
They're clearly doing that. But they're doing it on the facts as part of the trust delivery of medical care. So they're just one of the kind of they're the means, one of the means by which the trust is delivering its care. And that is a crucial difference in this case.
I understand that,
Yes.
but do you dispute that the consultants are, as a matter of employment law, employees of MainPay?
No, I don't dispute that. For a relevant period, they were employees. For a particular period, they were engaged by them. But no, we don't dispute that they are the employees. There's no dispute over that.
So when Kugler's employed nurses provide care, they're doing it for Kugler. But when MainPay's employees, who are doctors providing care, they're not doing it for MainPay.
No, they're not doing it for me. They're doing it for as part of the NHS trust delivery.
That's your point, that they're
Yes.
they've been seconded to somebody else and they're doing it for somebody else. They're not doing it for MainPay.
Yes.
And so MainPay are not providing medical care to the patients.
No, and they're doing it through a chain as well. So I'm not sure if that's actually very relevant. But
Does it matter?
No, it
I mean,
doesn't, yes.
does it matter?
I don't think
A&E had dropped out and MainPay's
Yes.
contract was with an NHS trust. We'll supply you with the services of our employed doctors. You say exactly the same would be...
Yeah, we say exactly the same thing. That on the facts, it's not the supplier of the medical care is not the appellant. It's the NHS trust. That's
And
really
that's a
what
question of substance and fact.
Yes.
Is that what the test? Just thinking it through, if you're right, this is
Yeah.
what the test is going to be in the future.
Well, so the test is just on the facts, my lord. That's the point. That it just depends what facts are found, for example, about the level of control, say, the NHS trust has as compared to, say, the appellant. It's all to do with the
But
the
hold on, the
matters.
test is economic and commercial reality.
Yes,
isn't it?
exactly.
Which is a fact-sensitive test
Yes,
of law.
that you put it better than I have, my lady. Yes, exactly.
But that's very established. I mean, there's nothing
Yes.
about that.
Exactly. But I do still say, I'm not sure if this actually is going to persuade you, but I do still say that there is a distinction in lots of these cases in that the person actually providing, where they're talking about the Court of Justice is saying you don't exclude upstream supplies of medical care, they're always looking at a person who is actually providing medical care, not someone such as the appellant who's providing a payroll service. I say that is a distinction. And may I just go on to some of the other cases to explain how because the facts are important, and the facts are very
No, you
different.
can't. I want to pick at this one just for a
Yes.
moment. So upstream, we've got a company in
Yes.
Kugler. There will be someone doing the payroll, presumably, for its nurses
Yes.
and doing the backroom stuff, which is what MainPay does. And they're providing the provision of medical services. So the case of MainPay, there's someone doing the backroom, and they don't do much else, but they also have these employees. And if you put both together, not certain there's a lot of difference legally. We understand the points. We understand that. We obviously see the facts. We've got a vision of what it all looks like and how it works. I mean, maybe it is just a question of degree, and that's a question of fact.
Yes.
Part of the fact, but
Well, perhaps if I go to the cases, and then that may bring out the distinction in the.
we said earlier, you take your course, but we don't promise not to interrupt.
Yes. No. That's fine.
Just before you move on, what I've written down your submission to be, the distinction is that in Kugler, the nurses who are employed by Kugler are providing care to the patients as part of Kugler's business. That's what Kugler's business is.
Yes.
To employ nurses to deliver care to the patient.
Yes.
You say it's different with MainPay because the doctors are not providing care to the patients as part of MainPay's business. They're providing care to the patients on behalf of the NHS organisation where they've been assigned to.
Yes. Yes.
That's-
Exactly. But then when we get to the upstream cases.
I understand that.
Yes,
That's a different point. That's a different point. I'm just looking at the simple case.
That is a simple case.
Yeah.
So, but
So you
yes.
say that the proposition that the provision of medically skilled personnel equates to medical care is false. You cannot equate those two
Yes,
things. Medical
exactly.
care is providing medical care to a patient, dressing a wound, surgery, whatever it happens to be, and the fact that you're providing members of staff who may be able to do those things is not in and of
Yes,
itself medical
exactly.
care. It just isn't.
No, it's not. And then when we look at the cases my learned friend relied upon, it is right that they that they speak about not excluding. So assume we've moved on from Kugler. When we then look at Malone Friend's next point, which is to do with the upstream supplies not being excluded, there isn't any example of the Court of Justice saying that if the supply it's looking at is not medical care at all, it's still okay to kind of treat that as an exempt supply. There's no example of that. Whenever they look at the point where a service is being used by someone else, the service itself is always a supply of medical care itself. So it may be a question of degree. You know, as I understand that one could say, well, actually, is that very far removed from the point where the service itself is not medical care, it's being supplied and then someone is supplying medical care. But there's no example of the Court of Justice ever going that far, and that's how far Malone Friend wants you to go. And again, just to look at some of the cases. So Malone Friend took you to LUP, first of all. That was tab 22 of the authorities bundle. And the context in which the Court of Justice is considering and rejecting arguments is very important. So the Court of Justice rejected an argument in LUP that activities carried out upstream from those provided by the ultimate service provider, to use that term, were not exempt. So they rejected it. But in my submission, it's important to look at why they rejected it. And the key difference was that the upstream activity in LUP was itself a supply of medical care. And we see that, may I just take you to, it's tab 22 of the authorities bundle.
This is Pathology Services by Dr. Sharman.
Yeah, that's the one,
by
yes.
his own private limited company.
It's exactly, milady. It's page 340 of the opinion, which is tab 23. And yeah, so here we do have to be careful about what the facts are. So 343 from the opinion of Advocate General Maduro, LUP is a private limited company incorporated under German law in which the sole shareholder is Dr. Sharman, a specialist in laboratory medicine. So Dr. Sharman himself has the relevant qualification. LUP conducted medical tests requested by 2 laboratory associations in which general practitioners were partners, and the inference is that it was Dr. Sharman himself who conducted the medical tests requested by the 2 laboratory associations in which GPs were partners. So what was happening here, and we get this from the judgment as well at paragraph 2, page 355, is that GPs had prescribed the medical tests in the course of the care they provided, and they were then carried out by LUP in the form of Dr. Sharman. That's what's happening here. And it's against that background that we have to consider what the Court of Justice said. So if I could take you to page 362.
They've lifted the corporate veil, haven't they?
Yeah, so they have. So if we go to 362 and we see kind of how the debate developed before the Court of Justice. And so just beginning at paragraph 23, so what the court says here is that although there seems to be agreement that medical tests, such as those at issue in the main proceedings, may be activities closely related to medical care, it should be ascertained whether those tests nevertheless may be medical care within the meaning of that provision, or the provision of medical care within the meaning of letter C of the same article. If that is so, those tests will be exempt under the 6th directive, irrespective of where they are carried out. And then what we have is a debate.
So what they're dealing with is because closely related appears in B, but not in C.
Yes.
If they're only closely related, you have to decide whether they're within B or C, and that depends on where they are, whether they're in a hospital or other institution. But if it's medical care itself, you don't need to decide whether it's within B or C.
No. If it's medical care, then they're saying, well, if it's medical care, it can fall within C, potentially. If it's just yes. I suppose B covers the supplies by a hospital, by a public, all that.
Or by an institution,
yes,
which can include laboratories. That was the argument.
Yes, that was one of the arguments. Yes, but what we have here is them debating whether the medical tests are themselves medical care. And there's a debate, and it goes on from really paragraphs 24 to 30, and then there are some of the parties are saying, oh no, it's not really, and then others are saying, yes, we think it is, and the court comes to the conclusion at paragraph 30. So what the court says is, moreover, medical tests, which as in the present case are prescribed by general practitioners as part of the care they provide, may contribute towards maintaining human health, because like any medical service effective for prophylactic purposes, they allow for the observation and examination of patients before it becomes necessary to diagnose, etc. And then the court says, 31, in those circumstances, as maintained by LUP at the hearing and as acknowledged as being possible by the National Court and the Commission, the court finds that in the light of the objective of reducing healthcare costs, medical tests such as those at issue in the main proceedings, which have as their purpose, etc., may constitute, they say may because there's been no finding of fact about it, they say may constitute medical care, and then at 32, this interpretation is consistent with the principle of fiscal neutrality. It will be contrary to that principle to make medical tests prescribed by general practitioners subject to a different VAT scheme depending on where they're carried out, when they are equivalent from a qualitative point of view in the light of the professional qualifications of the service providers in question. So one cannot ignore that the point that underlies all of this discussion is that LUP's supply, which was conducting medical tests through the lifting of the corporate veil, was itself, at least potentially, medical care. So that supply itself, this is important to note, that supply itself potentially satisfied the Kugler test. So medical services were involved, and they were supplied by a person who possessed the necessary professional qualifications. And it's really in that kind of situation where the Court of Justice is prepared to say, well, if we have that, and there's then further supplies, but we have that in the first place, yes, then that can potentially fall within the exemption, because the service itself satisfies or potentially satisfies the Kugler test. So, and that's a feature in all of the cases my learned friend took you to. There is no case where the Court of Justice has said that the kind of supply made by the appellant here, which is a supply of qualified persons to a recruitment agency, which is effectively what A&E seem to be, also qualifies, because it's obvious that the appellant's supply itself is not going to meet the Kugler requirements, so that it cannot, and the appellant is not in the same position as LUP, so there's no supply of any medical services by the appellant. As much as my learned friend kept saying doctor services, etc., that's not what the appellant is supplying. And just to draw a contrast, we've seen that there was a sole shareholder in LUP. That was Dr. Sharman, and he was a medical specialist in laboratory medicine. The appellant has a sole director. That's Mr. Harker. He is an accountant, and the appellant is a payroll company. So it has no medical expertise to on-supply. I mean, that's the point. In all these cases, there was some medical expertise that could then be provided further down the chain. But the appellant doesn't have that. It doesn't have that expertise in the first place. And that's why all it does is supply qualified people to a recruitment agency. So that's the key difference. And we get that difference as well in the case of Peters.
Before you leave LUP, was any point taken on the fact that LUP was a company not itself qualified?
I don't think so, just because that point would have been sorted.
That's been sorted by Kugler.
Yeah. Yes. So I doubt it. I don't think so. I don't recall it being a point.
In one sense that Mr. Firth, in a sense, makes this point that, of course, all these cases rely upon legal personality. So they say you can, in some degree, and this is where we're grappling with the dividing line between you, can to some degree treat the service provided by the employee as that of the company.
Yes.
And it's true that in this case, when you have a single shareholder who is the embodiment of the economic activity, they're one and the same. It's quite easy to look at the facts.
Yeah.
When you have a split with a much organisation, let's say for the sake of argument, 50 medics and one accountant, it's not that you've just got an accountant, you've got an accountant plus 50 employees.
Yes.
And this is why I have a little bit of difficulty with differentiating the cases. If you look at it purely and simply as a question of legal personality, when you lift the veil, you begin to look at the substance. It's quite easy to understand why a single person company would be treated as the single person who's the medical provider. You lift the corporate veil here, you have an accountant, you still have 50 people who are being provided qua employee. When you look at, I don't find it easy to analyse the upstream position. I understand the difference on the facts. I do understand as you go downstream, folding in somebody to the downstream service, which you've encapsulated in your paragraph 24, your skeleton, when you underline the word it's.
Yes.
It's brought in, it's integrated, folded and provided through its own service,
Yes.
which is a question of fact to degree. I mean, in a sense, you have these two arguments, but that I can understand more clearly than the upstream one at the moment.
Yes.
I'm not saying you're wrong, I'm just having trouble getting my hand around the differences when you either keep the corporate veil down or even lift it up.
Yes, but so I mean, what's happening in LUP is when they pierce the. I understand that the consultants themselves do ultimately they are involved in the provision of medical care, but that is that's only in the context of being used by trust to supply.
Exactly, that's your downstream argument,
Yeah,
if you like. It's your
exactly.
paragraph 24. It's its provision of care.
Yes.
The NHS Trust.
Yes, and I'm just wondering whether this point actually adds anything to that, as in distinguishing the facts of all of these cases. But I think there is a relevant point that whenever the court is saying these things about the purpose of the exemption and fiscal neutrality, they've always just said, oh, well, actually, this supply that we're looking at now, this very supply, so when we say the equivalent here would be the appellant's supply of consultants, not a supply of any medical care, supply of consultants. They always say, well, this supply before us can, in effect, satisfy the Kugler test because it does involve medical services and they are supplied by qualified people.
It's a problem with most references, as you know, when the court is providing an advisory opinion to the court below and is always dressing up its reasoning on a hypothetical basis. It all depends upon the facts because that's for you, the referring court, ultimately to decide.
Yes.
So one always finds this language, and one knows, of course, that on occasion they're desperately trying to lay down the law, but do it in constitutionally pure terms without really deciding it. They're still trying to.
Yes.
I mean, again, we of course are aware of the differences upstream in the facts of the cases, and we know that there's only a certain number of cases, and they've only examined a certain series of permutations of fact.
Yes, but I do say a common feature though is that in the supplies which are in issue in all these cases, they are all effectively capable of satisfying the Kugler test. I say that is a distinction, and the court hasn't gone as far as my learned friend wants you to go, which is to find that its supply, which we say does not satisfy, the supply to A&E does not satisfy, that is the appellant supply, it does not satisfy the Kugler test.
Yeah.
It's only at some stage...
Unless you allied the
Yeah.
consultants themselves, the supply of the consultants would be
Yeah.
a supply of medical
Yes,
services.
unless you allied the two.
Unless you
Yeah.
allied the two and you say
Yes.
that one is subsumed into the other
Yeah.
effectively,
Yes.
which I think was where we ended up this morning.
Yeah, yes.
But that's not that's not happened in any of these cases.
No,
you can certainly
exactly.
say that.
Yes. So in all these cases, there itself a Kugler compliant supply, and the court, and then one can understand why the Court of Justice says, well, it's okay if that Kugler compliant supply is then supplied onwards, and it's used for another medical supply because it itself is a medical supply. That's the point. It itself is medical care. So that's a distinction, whereas we don't have that here. And as I've said, the court hasn't gone as far, and I would say rightly so. That's because we don't have the Kugler compliant service here. That is a lot of these cases are just about degree, and the court has not shown itself to be prepared to go that far. For good reasons, I would say, because that would be beyond the wording of the exemption, which after all does have to be interpreted strictly and so on. There's all of those principles in the background. And I say that's why they haven't gone as far as my learned friend wants you to go in this case.
Well, maybe they haven't gone that far because they haven't had a case which raises that point.
Well, that's also possible, my lord. That is possible.
3 years ago, we'd have stopped this case now and bunged it off to London.
Yes. Yes. But I say, based on the cases they have decided, that it's clear kind of the way they'd be going with this one. because given that they're always looking at, oh well, is the supply we're looking at one of medical care? That's always a key thing for them, and then it's okay if it's onward supplied, and as part of someone else's service. That here they'll look at the supply and they'll say, well, actually no, this is simply a supply you're making to a recruitment agency of personnel. I hate to use the word staff, so I'm not going to use that word, but of qualified persons who are then used further down the line to actually provide the care. So my view is that they would be saying something like that, but that's just my view. Whether you agree with it is a different matter. Yes.
Your point is that in LUP, what LUP was supplying was tests
Yes, exactly.
provided by Dr. Sherman, probably.
Yes.
Maybe he employed other people, we don't know. It wasn't supplying the services of Dr. Sherman. It
No,
was supplying
exactly.
medical tests. That's what
Yes. It wasn't supplying Dr. Sharman to a recruitment agency who was then supplying Dr. Sharman to provide the medical tests.
Yeah.
Yes. And that's going too far, and that's stretching the directive too far as well. The exemption, I'm sorry.
Well, that's a different point. I mean, I think you can make the point that this is what this case is about.
Yes.
To say that it's going too far to extend it, well, that's a matter which I don't think we get from any of these cases. We have to look at.
No, you don't get it, but it's just, I would say, an inference you can draw from them, given that they always do have the Kugler compliant supply in the first place. And Peters, I think that was the next case my learned friend referred to. That's also a good example of that. I don't think you need to go back to it. It's at tab 34. And again, it's important that there was a supply of medical care in Peters. There was a supply of medical care. I mean, perhaps you should go to it. So
That was lab services, just
yes, he's a medical.
specialist in clinical chemistry. And
Yes, exactly.
Diagnostics.
Yeah, so if you go to tab 34, it's really paragraphs 7 to 9
7 to
of
9,
the
isn't it?
judgment.
Yep.
Yeah. So I think what that comes down to is that he's a medical specialist in clinical chemistry and laboratory diagnostics, and he provides medical care services to a laboratory company supplying laboratory services for doctors working in medical practices and hospitals. And his services, so Mr. Peters' own services, included evaluation services aimed at specific laboratory physician diagnoses, as well as medical assistance in transfusion medicine measures in specific treatment scenarios. That all sounds very medical. that is a medical, and the very nature of that supply is medical. And it wasn't in fact disputed, as far as I can see, that Mr. Peters was a medical specialist supplying medical care. So again, that is an important point, that when the court is faced with a supply like that, which on its face is Kugler compliant, it's much more willing to say, well, actually, if that's supplied to someone else and then that's used in a supply of medical care to the end consumer, as it were, that also qualifies. But I've already made the point that that's not the position that the appellant is in. And then my learned friend took you to X, but in my submission that doesn't really add anything. He in part relied on it to make a submission about the purpose of the exemption being to reduce the cost of medical care. And he pointed to that paragraph in some other cases as well, where the court says, and in fact we saw it in LUP, where the court were focusing on the purpose of the exemption. But in my submission, a purposive interpretation can only be taken so far, and it cannot have any bearing on the facts which disclose the economic reality and so on. So we say it's really on the facts here that the appellant did not supply medical care, the trust did. And it's not permissible to say that because finding that the appellant did not supply medical care will lead to the trust incurring some irrecoverable VAT. It instead has to be found that the appellant did supply medical care. That would involve essentially creating facts that don't exist. So I say do not do that.
Can I ask you,
Yeah.
I haven't understood, what are the practical consequences if the appeal, depending on the outcome of the appeal? I mean, if this is a supply is not exempt, then,
Yes.
then VAT will be collected from the taxpayer.
So we set it out in our skeleton arguments. It means the NHS Trust basically has some sticking tax.
Yes.
Yeah. So so in our skeleton argument, my Lord, it's when we're responding to the, I think it's the fiscal neutrality, or is it not that? Hang on, it's yeah. So it's page, it's internal. So it's really paragraph 45 of our skeleton. And then we make some points just to give you some background. So if the appellant supplies were treated as exempt, there would not have been any direct cost reduction for an NHS patient, but there may have been a cost reduction for the NHS Trust. And then we set out what the principal activity of NHS Trust is. It's not a business activity, it's outside the scope of VAT, but NHS Trusts also make business supplies, which include exempt supplies such as the provision of healthcare for consideration to private patients. Now, that doesn't seem to have been happening here, because it seems like, well, there's no evidence anyway that the appellant's consultants were used to deliver any provision of private healthcare as opposed to just the regular NHS patients. And then we say the fact that the appellant supplies have VAT added to them does not increase the cost of medical care as far as a patient is concerned, because their care is free. But the VAT on the appellant supplies, if passed on by A&E to the NHS Trust, and we assume that would happen, but again, we haven't got the details of that, but let's assume that happens, that would lead to the NHS Trust incurring a level of irrecoverable VAT. And then there's a footnote which just explains why they wouldn't be able to recover VAT. We've included section 41 in the authorities bundle, and that indicates that it is possible to recover VAT in some circumstances specified by the Treasury, but this cannot possibly fall within.
This is not on the list.
Yes, it's not on the list.
Does A&E get its VAT back? Do we
I'm
know?
sorry?
Does A&E get its VAT back? Is it
Does
taxable?
A&E get its VAT back
Well, it would
from
be-
the so the VAT?
Because the VAT would
Input
be
tax
charged
that
by
they charge
MainPay
out.
to
Yes.
A&E, wouldn't it? So
Yeah,
the
so
question
you
is
think
whether
they-
A&E
you think
gets
they-
its VAT back.
Yeah,
if it
so-
does.
Yeah, so unless yeah, so its onward supply is of the I don't know actually.
We don't know what
We don't
A&E
know
charges the
exactly,
VAT. We
yeah,
don't
we
know
don't
how
know.
that's characterised. But
Yes.
that's where if there is sticking VAT. So
Yes.
if A&E can't recover the VAT that it's charged by MainPay and it has
Yes.
to increase its costs,
Yes,
that's where it sticks, and it
Yes,
sticks at
exactly.
that level. But we don't know anything
we
about
don't know. We're kind of speculating, but certainly in theory, one could see. Well, if there's an increase if there's a VAT charge, then the NHS Trust may be lumbered with it. That in theory, but we don't have all the evidence about that.
It's always difficult to analyse because
Yes.
that's real. It's almost an internal government allocation of resources. It's up to the Treasury, for example, to subsidise those payments to the NHS if it wishes to.
Yes.
It's not something which is really. That's just a matter of government policy, isn't it?
Yeah. So if the NHS Trust incurs some sticking VAT.
Do
of
we
course-
even know if A&E pays a VAT inclusive cost? Can we don't even
We
know,
don't
do
even
we,
know
whether
that.
MainPay did charge VAT to A&E at the outset, and what that contractual arrangement is. I mean, it may be that MainPay has to absorb it itself. It's got a fixed fee arranged with.
I may have to turn my back and ask my.
It may not matter now. Maybe it's an overnight thing,
Yes.
but there's an awful lot we don't know about how
Yes.
this VAT's going to flow through, given
No.
the parties in the way.
Yes, because we don't have any details of the kind of last bit of the chain, which is A&E to the NHS Trust.
Assuming it's passed on to A&E.
Assuming it is, yes, exactly.
But I thought that your argument would apply in exactly the same way to what A&E supplies to the NHS Trust. A&E, on your argument, doesn't supply medical care any more than
No,
MainPay does.
no, it doesn't. No, as far as we know, because we don't have the contract.
Well,
but
we
yeah,
don't have the contract.
Yes. Yes.
But in any event, Mr. Firth made the point, which seemed to me quite a good point, is that the EU legislation has to be applied across the member states.
Yes.
And in those healthcare systems where costs are passed on to the consumer, and indeed if you have private patients here, the effect of this would be to increase the cost to the ultimate consumer.
The effect of it would be to.
The
Yes,
effect
I
of your
suppose
argument is
yes.
that the ultimate consumer would bear VAT on this element. of the-
Taxpayer.
Yes.
Yes.
Yeah.
Yes. Well, we're not making a point about that, my lord. We're not saying because of the specific arrangements that operate in the UK that has any bearing on anything. We only mention this just in case any of you were not aware of how it exactly worked here.
Well, no, I did ask the question, so I'm very grateful for the answer. But it can't affect the question of construction
No.
of the directive.
No, it can't. It can't. Yes, you do have the assessment to main pay in the supplementary bundle, and it was made on the basis that it had not declared the correct amount of VAT and so on.
So at the moment, we know main pay treated as exempt, which may be how it was characterised in their arrangements with A&E.
Yes.
They didn't account for VAT at the time. They've been assessed for VAT.
Yes,
So we don't know whether
We
that
don't
they
know.
can then call it back from A&E.
exactly.
But we also know, don't we, that the healthcare systems throughout the EU are all very different.
They
Some
are.
of them are state funded and some of them are insurance backed. So all the arrangements, the whole point about sticking VAT in the healthcare sector is
Yeah.
a patchwork.
It
And
is.
It works out differently in different countries.
Exactly, yes. So I think my next point then was, it was in response to what my learned friend said about the organisational structure. So his submission was that making the VAT cost ultimately borne on a supply of medical care depend on the organisational structure by which it is delivered is inconsistent with Court of Justice case law. And then he took you to Canterbury Hockey Club on the sports exemption and Ludwig on the financial services exemption. And I think I can deal with that point quite shortly, because we say his argument is a red herring. We do not say that exemption is dependent on the organisational structure by which a supply of medical care is delivered. Rather, we say there is no supply of medical care by the appellant. Now, the reason the organisational structure may be relevant, however, is that it may be relevant to who is making the supply of medical care, and that's how it's become relevant in this case, because in this case the NHS Trust control of the framework in which the consultant operated indicated that actually the purpose of the supply of the consultant was to facilitate the provision of medical care by the trust. So we say it is, I mean, that's why we see it featured in the findings of the first year tribunal. So it went to that. They ultimately found that all the evidence shows that the supply of the consultants is part and parcel of the NHS Trust supply, and it can be relevant on that point. And my better friend briefly responded to Horizon College. Now, we're not making a big point about Horizon College. That was a different case about education. But we say an analogy can be drawn. So, and it's quite a useful case to consider. And just before I take you to it, very briefly, what happened in Horizon College was that the Court of Justice decided that it was not a supply of education for Horizon College to make available for consideration a teacher, the teacher's name was Mr. Hadra, to a host establishment in which that teacher temporarily carried out teaching duties under the responsibility of the host establishment. And it's quite useful because we can see parallels between the host establishment and the NHS Trust here, and between Horizon College and the appellant, and between perhaps the teacher and the consultant. So may I just ask you to look at it? So it's tab 24 of the authorities bundle. So tab 24 is the judgment, and if you could go to paragraphs, so it's internal page 406, and paragraph 5 just states Horizon College is an educational establishment. 6. During the period relevant to the main proceedings, Horizon College made some of its teachers available to other educational establishments. That's the host establishments. There wasn't actually an employment relationship. That's just one thing to note, but it doesn't seem to have made any material difference here. Made some of its teachers available to other educational establishments, each of which assumed responsibility for the teachers working there. And then 7, a contract was concluded in respect of each placement between Horizon, the teacher concerned, and the host establishment. Under the terms of the contract, it was for the host establishment And again, here we see some of the similarities with the findings made about the NHS Trust to define the duties of a teacher concerned having regard to the duration of the placement and the role assigned to that teacher at Horizon College. In addition, the host establishment was required to pay statutory liability insurance for the period of the teacher's placement. Now here we know the appellant, no evidence the appellant ever paid any insurance, but the consultants, whilst providing the NHS's supply of care, would have had the usual NHS indemnity cover. So if someone wanted to sue, they'd go after the NHS rather than the individual consultant.
Well, what is the position? Because as a matter of tort law, the consultant would owe a duty, presumably.
Yes, he would, but because he's under the responsibility of the trust, it would always be the trust that would be sued. Yes. So,
and the trust indemnifies the people who work for it.
Yes, they have a kind of the NHS indemnity.
And I think if you tried to sue an individual consultant, if they were working for the trust, the consultant probably could strike themselves off the claim form, couldn't they? Different if it's private.
Private,
you would sue the consultant by their name.
Yes, you would. But if they're GPs, you sue all the partners. But if it's just someone in the working in the hospital, you just sue the trust that's responsible for the hospital. Yes. And then the teacher's salary continued to be paid by Horizon College, just as we know that the appellant pays I suppose the appellant supplies onto the appellant is the employer, so the appellant is the one operating the payroll function. The host establishment was required to reimburse Horizon College in respect of that salary without any profit uplift, but there was a bit of an uplift in our case. Horizon College did not charge that. And what's quite interesting is to look at the analysis by the Advocate General, as is Advocate General Sharpston, which is at tab 21 of the bundle.
23, I think.
Is it 23? I think in mine it's tab 21, the opinion.
We're 23.
Oh, are you? Okay. And it's page 400. Is it page 406? No, it's not. It's 386. Okay, is it? Yes, sorry. Same here. I just have a different tab. Okay. So it's page 387. So 387, she describes the host establishments as intermediary establishments, and then you can see that under the heading the nature and the recipient of the service provided, at 43 she sets out a possible analysis, which is both Horizon College and the teacher, Mr. Hedera, were providing a service only to the respective intermediary establishments, not to the students of those establishments. I suppose students may be the equivalent of patients perhaps, and then the students were in a contractual or comparable relationship with the intermediary establishment, as in the host establishment only. Horizon College's secondment arrangements stipulated that it was the intermediary establishment which both controlled and took responsibility for the teaching, one could say, to an analogy, medical care, provided by the seconded teachers, or the consultants in our case. In Mr. Hedera's case, not specified how much control the education centres exerted over his teaching, but it seems clear from the payment arrangements described that the students paid the centre for his services in exactly the same way as if it had employed him, and therefore would have a claim only against the centre in respect of the quality of those services. Again, one could draw a bit of analogy there, patients suing the NHS Trust. And then 44, on that analysis, the educational service which the students receive was provided to them by the intermediary establishments, that's the host establishment, even though it was Horizon College's, well, they call them employees here. So I think there was a finding somewhere they didn't have an employment contract, but perhaps I got that wrong. I think I saw that, but I'll come back to that if that's wrong. They describe it, she describes them as employees here. And Mr. Hedera, who concretely did the teaching. By contrast, the service which Horizon College and Mr. Hedera provided to the intermediary establishments was not education or tuition per se, because it was the students, not the establishments, who received such education or tuition. The service was rather the making available a person's staff, or in the case of Mr. Hedera himself, to enable the intermediary establishments to provide education or tuition to their students. So even though she uses the term employees there, slightly further, if you look at page 379, what the Advocate General says there was at 13, his status was covered by regularly renewed contracts, which express
That's Mr. Hederer.
Mr.
But
Hederer.
Mr. Hederer's got nothing to do with Horizon College. There's two different references.
Yeah.
Horizon College supplied its staff. Mr. Hederer was a freelance who supplied himself.
Yes, that's right, Nord. So Mr. Hedera has no employment relationship with Horizon College. So when we look at the Advocate...
He's got nothing to do with Horizon College. It's a completely different case.
So when you go to 43, my lord, one of the analyses is that both Mr. Horizon College... I see, okay, yes.
If you look right at the beginning of the Advocate General's statement of the facts,
Yeah.
she explains that there are two references. Paragraph 2.
Yes. Oh, I see, yes. So Horizon College...
One of them
You're
is
right,
Horizon
yes.
College, supply of teachers by one school to another, and the other is an independent teacher,
Yes, sorry, my lord,
Mr.
you're
Hederer,
right, you're right.
who's a
Yes.
freelancer and
Yes.
goes and works in various other places.
Yes, so Horizon College provided teachers in the plural, and as you say, Mr. Hedera was a different case. So when we get to her analysis, she is referring to she's referring to Horizon College and Mr. Hedera because she's covering the facts of kind of both references. She's trying to include them, but both in one analysis. And then she says at 45, consequently, such a service could not be exempted as education or tuition under 13A 1 or J. But then you'll see that there are some submissions made, and what she then says at 49 is, for my part, however, I agree with the Greek and Netherlands governments and with the Commission in this regard. When one educational establishment makes teachers available to another such establishment, where they teach the latter students under its instructions and responsibility, the supply made by the first establishment is not of education, but of teaching staff. And, as the Commission pointed out at the hearing, the education, etc., which students receive in an educational establishment is not merely what is provided by teachers from their own knowledge and skills, rather it includes the whole framework of facilities, teaching materials, technical resources, educational policy and organisational infrastructure within the specific educational establishment in which those teachers work. Now what happened was that the court seemed to pick up on some features of that analysis so if you then go to tab 24, it's page 409 and it's begins at paragraph 18. So it's the bottom of page 409. Admittedly, as Horizon College essentially submits, the transfer of knowledge and skills between a teacher and students is a particularly important element of educational activity. 19. However, in view of the requirements of the case law referred to earlier in the judgment, the fact that such a transfer is taking place is not by itself sufficient for the mere supply of a teacher to an educational establishment for the purpose of carrying out teaching duties under the responsibility of that establishment to be described as educational activity. Indeed, as the Commission submitted, in essence at the hearing, the educational activity referred to in Article 13A1 consists of a combination of elements, which include, along with those relating to the teacher-student relationship, those which make up the organisational framework of the establishment concerned. And then 21, however, according to the terms of the placement contracts at issue in the main proceedings, it was for the host establishment to define the duties of the teacher concerned, having regard to, etc. And in addition, the host establishment was required to ensure the teacher the period of his or her placement. And then 22, accordingly, the making available of a teacher to the host establishment in such circumstances cannot be regarded of itself as an activity capable of being covered by the term education. As the Greek and Netherlands government and the Commission essentially contend, the contract concluded between Horizon College, the host establishment and the teacher concerned aims at most simply to facilitate the provision of education by the host establishment. So what I've tried to do, albeit in a fairly haphazard way, is to, it's not a big point in our case, but we do say that one can draw an analogy at least. So let's say we were to try to apply what was said in Horizon College to the present case. It could equally be said that it was not a supply of medical care for the appellant to make available for consideration a consultant to an NHS trust, obviously via A&E, at an NHS hospital in which that consultant, as a locum, is temporarily carrying out medical duties under the responsibility of the NHS trust. And that's finding a fact by the first year tribunal. And then in particular, medical care doesn't consist merely of the literal supply of the consultant, but it includes what really the first year tribunal has found is more of an organisational framework in which the consultant works. So following the local policies of the trust when it comes to prescription of extraordinary drugs, that kind of thing, all those other policies. And it's for the NHS trust to both define the duties of the consultant and, insofar as through the NHS indemnity, insure the consultant. So we could say that the making available of the consultant simply facilitates the provision of medical care by the NHS trust. So it's not a big point, but we say that the analysis it is of some use. It can be kind of applied across in a way, albeit it's a different exemption, but some of the features discussed are similar to some of the features that emerge in our case. And it does go to who is making the supply, because here we say, well, it's the NHS trust, and we can draw upon some of the features that were discussed in
This was under 13A1, I think, of the directive, wasn't it? Which
yes.
I'm just trying to look at that to see how it compares with subpara C.
Yeah, so 13A...
So it said, I think, on page 403 of the judgment. So member states
Yes.
duty to exempt, and then A1.
I think that's the equivalent, that may be the equivalent of B, but... no, sorry, it's the equivalent of I and J, isn't it? Yes, I and J. So I wonder where J is. Page 16. Oh, I see. Okay. Yeah, we do have the article here, my lord. If you go to tab 4 of the bundle, we've got both I and J. And it's page 16. And I is the I that we see. Obviously, this is in the Principal VAT Directive here at 16. But the provision of children's or young people's education, school or university education, vocational training or retraining, including the supply of services and of goods closely related thereto, by bodies governed by public law, having such as their aims, or by other organisations recognised by the member state concerned as having similar objects. And then J, tuition given privately by teachers and covering school or university education. So it's not so I and J are not a million miles away from B and C, but I'm not trying to say that that there's a very close analogy.
What you're asking us to consider is when you have, what we were discussing at the outset of your submissions, this sort of folding in or integration of a consultant into the NHS so that it's absorbed into the NHS and becomes its service. Is there anything in I and J which would mean that the analysis here in Horizon is peculiar to I and J, or is your folding in analysis, in a sense, one can draw some inspiration from this, at least as a comparable, if you like?
Yes, exactly. We don't think there's anything in I and J that means it can only be specifically confined to Horizon College. That one can draw a bit of a broader analogy from it.
So you would say, albeit in a different exemption,
yes,
your folding in analysis has been applied.
Yes, exactly.
Which distinguishes between the actual provider of the service as a person, the consultant, the teacher.
Yes.
And then the provision of teaching or care as part of somebody else's service.
Yes, exactly. And that gives us an indication, given that we don't have a Court of Justice decision specifically on our exemption on this point, that gives us some idea at least of how the Court of Justice may deal with a case a bit like ours, if it ever does. Because we know how it's dealt with it in not completely dissimilar circumstances in education. So we say that's we say it does lend some support to our argument.
It also, interestingly, would tend to suggest that the question whether main pay is characterised as a payroll services company isn't actually it's not a decisive question at all, because in this case, Horizon College was an educational institution. It did provide education.
Yes.
And you see that at paragraph 23 of the judgment. But that doesn't make any difference to the analysis. So even if MainPay did provide medical care to people directly through its employed doctors, you would still, I think, say that that's not what happened in this case. In this case, what it did was supply staff to the NHS Trust to provide care.
Yes, because you still have the organisational framework and so on. You don't still only have literally the supply of the person. So you have that in Horizon College and you have that in our case. So that again indicates that the person making the supply is not Horizon College and it's not the appellant. So that is relevant. I mean, that's the point about Horizon College, that when one looks at kind of everything that's going on, you don't supply education just by there being a teacher. You look at kind of all the other features of the place where they're teaching and so on. And similarly, we say the same, that you don't just look at the consultant, you look at everything else that's going on. The consultant is operating under the NHS framework, essentially, just as the teachers here were operating under the framework of another establishment. So we say that is important, but yes. And here we have the added feature of we don't even have the appellant making a supply of medical care. We don't even have that either. So a fortiori, this analysis would apply in Horizon College. I think I'm now placing more weight on Horizon College than I was intending to, but it is actually quite fairly helpful. But it still does not it's not the biggest part of our case, but I say it is still a relevant kind of case to look at if we want to get some idea of what the Court of Justice might do.
And just a matter of interest, it doesn't look as if this judgment deals with the case of Mr. Hederer. I mean, it's a bit odd having one
Yeah, that's kind of what confused me more.
general's opinion
Yes.
dealing with two references, but,
Yes.
but maybe the second reference wasn't taken forward, or maybe it went to a different judgment.
Yes.
My lord, there is a separate decision on Hedera.
Oh, there is. Oh, okay. Right. Well, it's just not in the bundle. No, it's not in the bundle. But I don't think it actually adds anything. I'm sure we would have looked at it at some point over the last few years, as this case has been going on. I don't think it would have added anything. But we can have a look at it anyway, my lord, and see if it.
It's a rather different issue, I think.
Yes.
If it helps, the issue was that Mr. Hedera wasn't sufficiently private.
Private. It refers to private tuition.
What about
Jay.
private?
Yes. Thank you.
Thank you to Malena Friend. So I think that's everything on Horizon College. And then Malena Friend then referred to, after distinguishing Horizon College, he referred to Clinicum, and he was suggesting that it was. I think he said it's the only authority that we rely on to support our argument that the doctors have to be acting independently of the NHS Trust. But just to be clear, we do not rely, and we in fact do not need to rely on any authority to support our argument that the appellant does not supply medical care. We rely on the facts found by the first tier tribunal, and we've only mentioned Clinicum in paragraph 20 of our skeleton argument to contrast the position of the doctors in that case who were said to be acting independently of the hospitals in which they worked, although the basis for that is not really very clear. But that was seemed to be the agreed position, that they were acting independently of the hospitals in which they worked. And we contrast that with the consultants supplied by the appellant, who were not acting independently of the hospitals in which they worked, but were being used by the trusts that operated those hospitals to deliver the trust supply of care. So we simply refer to Clinicum in part and say, well, Clinicum was different to our case. But we're not relying on it as an authority for an argument. We're relying on the findings of fact. So just to be clear about that point. And then Malone Friend did refer to fiscal neutrality a few times in his submissions. Now, my understanding was that the appellant's fiscal neutrality argument has, the argument was that it was being treated differently to self-employed locums, but that argument has fallen away in light of what we say in paragraphs 52 to 55 of our skeleton, which is really that if, and bear in mind this is an if, because we don't have any evidence, there's no judgment about how self-employed locums are treated, but we said if the self-employed locum was doing what the consultants supplied by the appellant were doing, i.e. providing services to the NHS Trust to enable the Trust to make its supply of medical care to patients in its hospital, then the self-employed locum services, like the appellant supply, would not be exempt. There'd be no differential treatment. But as my lady has pointed out, there was never any evidence in this case of what a self-employed locum, how its supplies would be treated. Or there was no judgment indicating what the correct treatment was. So the appellant essentially just asserted that the supply would be comparable. But even that has now fallen away in light of what we say about what's going on in this case. If the same thing was going on with a self-employed locum, we'd have the same outcome. So you have no differential treatment.
So, because cases like LUP
Yeah.
do tend to suggest that if you just had a self-employed consultant who contracted with the hospital, say, to provide his services either directly or through his own company that was just a look-through company, that he might well be within exemption because he'd be within the bubble of medical services then. Doesn't it
Yes,
a bit like that?
potentially yes, because his own supply is he is supplying medical
He's just
care.
supplying himself through
Yes.
himself or through his own company. It just,
Possibly.
it's not for us to decide, and I'm sure we won't. But it does look like there's some quite helpful authority for a doctor if he was doing that in
Yes.
the European court. So you can't take it as read that it would be that he'd be outside the medical
No, exactly.
services exemption.
Yes.
Um,
But then he is in a different position then
yeah.
to the appellant, so they're not actually comparable.
Quite, but that's the point you
yes,
make. But it
exactly.
sort of just begs the question each way round, doesn't it?
Yes.
But if the company was doing the sort of things that MainPay was doing, the consultant was on those books, you'd say, well, exactly the same analysis
Yes, we
follows
would.
as here.
Yes.
So it,
It's there.
doesn't
the
get us any
but
further, does it?
It doesn't get us any further. No. May I just turn my back on you for a moment?
We'll do it tomorrow. I've got tonight. I don't want to have to wait too long for it, of course, beginning of next week. It's just, it really is just, you know what the answers are. It's when they want to make sure someone gets the connection with whatever language it says. There could be a test and things. It's really personal if they want to say anything about that. You'll lose it.
Yes, so, Lord's Lady, we say there's no error of law in the upper tribunal's decision. Effectively, what the upper tribunal did was it upheld the first tier tribunal's multifactorial assessment that there was no supply of medical care by the appellant.
It doesn't articulate the test in the way in which it's been advanced to us today, does it?
No, but that's not an error. I would say that's not an error of law, because what was ultimately found by the first tier tribunal was on the facts there was no supply of medical care. That was really the finding, and there was a difference of emphasis because the factors that I've now relied on to say actually what's going on here is that there's a supply by the NHS Trust of medical care was instead relied on by the first tier tribunal to find there's a supply of staff rather than a supply of medical care. But it doesn't amount to an error of law because we get to the same conclusion, which is actually there's no supply of medical care by the appellant. So I say there's nothing. There's nothing.
Just think about that.
Yes.
I don't think you're disputing that there's a two-part test. You're just applying it quite differently
Yeah. So
from the case law, from the European Court case. So we accept that the European Court lays down the test,
yes.
and that there's the two-part test, which is not referred to in the list of propositions from case law.
No.
But you say so, and the test they apply is. I'm just trying to find the paragraph. It's between the framework point and the, if you like, the discretion of the. I mean, they don't frame it in those terms. I mean, it may not matter at the end of the day, but they. at least on one view, they haven't framed the test in the way that Mr. Firth has put it, in which I don't think you challenge.
No,
You say that the application of the test on the facts leads to the same result.
Yes, well, the test. I mean, this is a Kugler point, but really Kugler just says, well, there are two matters that need to be satisfied. You have to have medical services involved, and they have to be provided by people with the necessary professional qualifications. And those factors were looked at by the first tier tribunal and the upper tribunal. They may not have looked at it by saying, well, Kugler says this, and we're applying that, but they looked at those very factors. And their conclusion was, well, really what's going on is that it's what is being supplied. There are medical services being supplied. There is medical care being supplied, but really it's under the kind of, it's part and parcel of what the NHS Trust is doing. And the consultants are clearly professionally qualified, but they're really, I mean, it didn't go as far as what I'm saying now, which is they discharge the NHS Trust's supply of care, but they said that means that the appellant is not supplying any medical care itself.
Can you just tell? It made me just. I want to be able to identify precisely what test the upper tribunal used. It's really from paragraphs 94 onwards, where they identify tests they've applied or not applied.
They were really looking at a different point, weren't they? I mean, nobody's disputing the test, the Kugler test. I mean, we've had a lot about it today. But as I've understood it, it wasn't that anybody was saying there aren't some medical services being made here. The question was, who are they being made by?
Yes.
Which isn't anything to do with Kugler, really.
No,
it
not
is,
really.
I suppose, on the appellant's argument.
Yes.
But it's a conceptual argument rather than being one devoted to the text of what Kugler says.
Yes.
Well, as I understand it, it was common ground before the FTT that all you needed to ask was, is the supply of staff? Because if it was a supply of staff, it couldn't be a supply of medical services.
Well, I'll check with my learned junior, but sorry, let me.
That's what they rejected. You've got 94 and 95.
Yes, the upper tribunal rejects it, but then the FTT, that's how it is.
Yeah. I mean, it was, but my learned junior said only because, well, if it's not a supply of medical care, then the label that's given to it is supply of staff.
Right.
But really,
I suppose once you've decided it's not, then the only thing it can be on the facts. It could be anything else, and that would be sufficient. On the facts, it must have been a supply of staff.
yes, exactly. That's just but you don't really need to call it anything. You know,
No,
if it's,
no.
yes.
One's simply deciding, is it the provision of medical services? If not, then that's the end of it. Doesn't matter how you categorise what it
Is there a supply of medical care? If not, does the appellant supply medical care? If the answer is no, then that's the end of it. Within B, I mean, that was within C, that was a focus in the upper tribunal. And there's a paragraph, I think, in the upper tribunal's decision where they say, well, no real reliance has been placed on B. So, yeah, but it's really about, does the appellant supplies, do they fall within C? That was the argument, really. And then ultimately what the upper tribunal
But as Mr. Firth said, it doesn't make any difference whether it's within B or C, because it's the same question, it's medical care.
Yeah, ultimately it's the same question, yes. It's C. I mean, under B they couldn't qualify, under B. Because when you look at the terms of B, it says, in B anyway, it says by the hospital, etc. They're not one of those bodies.
No, but then you get into item 4.
Yes, you do. Then you get into item 4, which has the in, but then again that itself refers to the supply of medical care. So if there's no supply, this case just comes down to the supply of medical care by the appellant, and if actually there isn't, then it can't qualify any.
But what is said against you is which bit of the Kugler paragraph 27 test doesn't qualify as medical care. Now that's how they'd like to frame the argument, I guess, because that would suit them. And I think, just to answer that, your point is it's not the Kugler test in and of itself. Well, Kugler isn't met at all, you'd say, by main pay, because what they're doing is just something different.
Yes.
And you can like that or not, but that's the submission, isn't it? So it's neither bit of the Kugler test is met by main pay, although it is met probably by the trust when they're using the consultant to do whatever they're doing.
Exactly.
So that's the point it comes back to.
Yes. I think actually those are my submissions. So unless there's anything else I can help you with.
Thank you very much indeed.
Thank you.
my lady. The first point I make in reply is that this is not an either-or situation. It's not either the NHS is making a supply of medical care or main pay. It can well be both, and there can be multiple parties making a supply of medical care that all contributes ultimately to one ultimate supply of medical care to the final patient. If I may then move on to what my learned friend sought to get out of the upper tribunal judgment, could I take you back, please, to the paragraph 117? Because you have to understand this observation in the specific context of the arguments that were being put in that court, which are all related to control. 117, they say we have no hesitation in rejecting this argument. Then they talk about Article 10, and then they say, whilst it is true that the activities of the employee are treated as part of the economic activities of the employer for VAT purposes, so the supplies made by the employers in the course of their employment are treated as supplies by the employer, that does not mean that each and every characteristic or attribute of the employee, such as control over clinical decision-making, is thereby deemed to belong to the employer. In this case, as a matter of economic and commercial reality, it's impossible to say that MainPay, an entity which had no medical qualification or expertise or knowledge, exercise any degree of control over the decision-making. So the upper tribunal accepts that the activities of the employee are treated as part of the employer's economic activity. The specific point they were dealing with there was specifically relating to control of clinical decision-making. I learned that Friend's case is, as I understand it, based on not attributing any of the activities of the employees to MainPay. It's not that he's just saying don't attribute the clinical decision making, he's saying don't attribute anything. As far as he's concerned, HMRC are concerned, we hand over the member of staff and what happens thereafter is of no consequence. But what this tells you, and what is plainly correct, is that the activities of the employee are attributed to MainPay, and those activities are. Well, what else are they? What does my learned friend say was attributed? And the answer seems to be nothing. Whereas my argument is it's the medical services. They are engaged to provide. We are asked to provide medical services to doctors. We provide medical services to the doctor. When the doctor is, as MainPay employee, providing clinical decision making medical services in general, is that not the activity of the employee? Yes, it is. And if it is, then on what basis do we not attribute it to the company of which they're an employee? There's been no answer to that. It seems to come down almost to an element of cosmetics in the sense that, well, you're MainPay, you're a payroll company. Therefore, well, we can't understand how you could possibly be providing the medical services of doctor. But if we were called sort of MainPay medical services and we did exactly the same thing, and then things might be different. I mean, I'll come on to Horizon in a moment, but ultimately, starting with the question of which activities of the employees do you attribute to MainPay? My learner friend doesn't seem to have anything to put in that box, and I say, well, it's the medical services. And in fact, the upper tribunal seems to support that there, because they say, well, we agree, the activities of the employee are.
To finish your sentence, are those of the employer.
Are treated as part of the economic activities of the employer.
Yeah.
Apologies, I was reading the first few.
No, that's right. No. It's the attribution. That's what it boils down to. This. If the employees are providing medical services, then as a matter of ordinary principle, that applies to you attribute those to the employer. That's the issue here, isn't it?
Yes, and Kugler only makes sense on the basis that you do attribute the activities of the employee to the employer, because that's how you can then say, well, this person, who's a legal person, A, is providing medical services, because on the ground, who is providing medical services? It's a natural person. And B, has the relevant qualifications. Well, Kugler didn't have relevant qualifications, but the person actually providing the care, carrying out the activity, did. And so Kugler only makes sense on the basis that you do attribute what the employee does to the employer. And then I learn a friend's trying to say, well, it's different here. It's very different. What he said repeatedly that what Kugler did was different to what MainPay did, because I think the refrain was, well, Kugler were definitely providing medical services and were definitely providing medical care. But given that to understand what Kugler is doing, we have to look at what his employees were doing, and those activities are then attributed to the employer. There is no distinction there.
How many employees does MainPay have? Very roughly, finger in the air. What sort of, just range? Have we got an idea? Not 1,000? Is it 10? Is it 50? Or what's very roughly?
Can I turn my back
Yes,
for
of
one
course.
moment? 50 to 100 is what I'm.
So, this is where I have a little bit, this is where I'm uncertain at the top end of this. In the case of Kugler, you've got one company, one employee.
Yes.
You say, in the case of MainPay, you've got one company, one shareholder, an accountant, and 50 employees.
Yes.
So, what's the difference between the two?
Yes.
You've got 1 and 50, and they had 1 and 1.
I mean, consider this. Instead of a one-man company, a group of doctors get together and say, we're going to share the administrative burden.
Instead of a set of chambers. And
Instead of a set of chambers, or well, if doctors were setting up chambers, I might be surprised that if a group of doctors say, well, let's get together and we'll provide our services to the NHS as essentially locums, doing what they would have done directly through this company, and there's sort of 10, 15, 20 of them, and they say, look, there's enough of us, we're going to get someone in to come and do the accounts and manage our payroll for us. How is that different to MainPay? It's not different to MainPay, in my estimation. Because at the end of the day, you're attributing the activities of the employee to the company, and the benefit the employee perceives they have from operating through the company has no bearing at all on what the end user gets. They get the same thing. And that's why, I was going to come on to it later, that this distinction, my learner friend seems to leave it lingering out there that maybe we can save the self-employed locums, even on his case, but you can't. You cannot. And he's quite clear about that in his skeleton argument. In HMRC's case, the self-employed locum who supplies their services to the NHS is outside of the exemption from medical care, which is surprising, and we say wrong. But there's no wiggle room there. I mean, my learner friend can make all the submissions he likes about MainPay being a payroll company, but at the end of the day, when you look at what is done, his argument is that because you folded that doctor's supply or activity into this activity of the NHS, it sort of loses its identity, and there's no supply of medical care. And that must be true whether it's MainPay, who are providing a doctor to provide medical services that are folded in, or whether it's a self-employed locum. So there is no wiggle room there. And that's why the consequences of this decision are profound, because billions are spent on locums every year. So it is an important decision. And it's no good in my submission of my learner friend holding out the possibility that in different cases a court might come to the rescue of a self-employed locum in a different way. There's no distinction. And equally then, turning to this proposition, well, if you incorporate, or your supply is incorporated into the supply of another, it ceases to be whatever it would have been prior to that incorporation. Well, there's no support for that in any of the medical cases. I'll deal with Horizon in a moment, which turns entirely on the meaning of education. But there's absolutely no support, and it's clear that in LUP, the services were incorporated into a wider supply of medical care. But the court didn't say, well, either that means it isn't exempt, or you need to investigate fully that to check something. Because this is a fundamental point. It is, my learned friend has no case in the context of medical exemption that you can point to that supports him. None. Every time the court's been asked a question like this about upstream activities or the organisation, the structure, that's Clinicum, LUP, and Mr. Peters, it is given an affirmative answer. And you've been through the reasons this morning as to why it's given affirmative answer. But front and centre is often the purpose of reducing medical care. So every time the court's been asked this sort of question in the context of medical care, it said, yes, that can be exempt. And my learned friend can't point to a single case. And that ought to give this court serious pause for thought. And, I mean, it's, just to develop that point a little further, it would be surprising if, in stating clearly the conditions for exemption and developing and explaining what medical care is, and we've seen it across the cases. For example, in the X case, it said, well, if you're doing consultations, or your employees are doing consultations directed at diagnosing and assisting with medical health problems, that's medical care. It would be surprising if in none of these cases the court hadn't spelled out or given some hint of this lingering but fundamental limitation that it must in some way retain its independence. It must not become folded into someone else's supply. But that leads me on to Peters, because that really is a case that my learned friend cannot explain, because Mr. Peters essentially offered his time to this company, I think it was LADR, in return for £6,000 a month. And then LADR provided all sorts of diagnostic services to GPs who provided them to patients. It is absolutely obvious that Mr. Peters, his activities were folded into the activities of LADR.
Is that right on the facts? I mean, he was providing he was getting a monthly payment for the provision of agents, well, of services.
Yes. So
It didn't. I mean, I would have to go back and check the facts, and we will do, to see what level of integration there was and whether that could or might not have been relevant.
well, maybe we should go back to the facts, but it's well, maybe in fact we should then, because this could be an important point in this court's decision. So Peters is behind tab 34.
So the facts are really 7 to 9 on page 544. So he provided services to LADR. He received monthly remuneration for providing services. I mean, they talk about him providing services. I think that's what made me think that it wasn't, if you like, a folding in or an integration case.
Well, when you understand what my learned friend means by that, he's saying, well, what you've done is you've fitted into the framework of someone else supplying their medical care, and then you lose your identity. But in my submission, that must also be true of Mr. Peters, because he's supplying his services to LADR for £6,000 a month. LADR is a company that is providing medical tests or laboratory services to doctors. And so Mr. Peters, his time doesn't retain any separate identity from what LADR was doing.
At least it doesn't appear to have been decisive in the court's thinking. The court wasn't addressing itself to this folding in issue, was it?
No, but I mean, we know from other cases that if the court thinks you've asked the wrong question or missed an important point, it picks you up on it. It did that in LUP, it changed the question. In LUP they said, we think these might be closely related. The court said, actually, you need to consider it for medical services. And a similar thing happened in X. They said, we're going to reformulate this question. It's not the right question. So if they thought that this was wrong, or they would be giving an incorrect answer because of these the way it was presented, they would have reformulated it and said it. But again, I mean, if we're looking at where the case law has got to, at the very least, this supports my case, and at the very least, there is no case supporting my learned friend for the revenue.
Okay. Yeah, the second question wasn't relevant. That was question 1 referred by the National Court, wasn't it? Question 2 was about confidentiality, which isn't really on.
Well, but That is potentially important though, because that's the only reference to someone asking, does there have to be some sort of framework in which medical services under C have to be provided in order to benefit from exemption? The court says no.
Yeah.
So the only opportunity he's had to in this case, he had the opportunity to talk about frameworks, and it said you don't need a framework, and it re-emphasised just the two conditions.
Yes.
Whereas my learner friend seeks to add a third condition that also must not be folded into someone else's supply. And then we come to the purpose, and we've seen throughout this morning and early afternoon in my submissions, the court repeatedly going back to the purpose to assist it in interpreting the terms of the exemption and how to apply them. And where it has found that an interpretation would increase the cost of medical care, it has looked for an alternative interpretation and generally taken it. So you've seen that in Kugler, you've seen their rejection of the upstream point in LUP, and you see it again in Peters and X. So every time it's looked at the purpose very carefully. And there really is a chicken and egg situation, because my learner friend says, well, purpose is only relevant if you've got medical services. But it can't be relevant to determining what medical services are in the first place. Well, then how can the purpose ever help us in interpreting the legislation? If we have to decide what it means first before we come to the purpose, then it can't possibly influence that. But where you've got something that could well, on one interpretation, fall within the exemption, that's exactly where the purpose helps you. And so in this situation, my learner friend accepts, well, medical services were provided by the doctors. He just says, well, that was part of the NHS's supply. But given we've got the basic elements of the exemption, he's therefore asking you to do something, adopt an interpretation that would take us away from the exemption, and thereby increase the cost of healthcare. And therefore, that is the sort of interpretation we've seen the court consistently turn away from. In respect of the discussion about, well, first, how did the VAT aspect unfold in this case in terms of A&E and passing on? And second, national level medical care and how it's funded. As regards the specific facts of this case, that cannot be relevant. When you see the court considering the purpose, it doesn't say, well, in this case, we've looked at the contract and we can see it's VAT exclusive, or so that they would have to ask at VAT, therefore that influences our interpretation. That would mean you get different interpretations depending on what the underlying contracts were in a particular case, which is plainly the wrong approach. These concepts have the same meaning across all sets of facts. And when you see the court talking about increasing the cost of medical care, it is absolutely plain that all it means is that by adding VAT to this, you are liable to increase the cost of medical care. It's as simple as that. The suggestion that in particular cases, the sticking VAT may have to be borne by someone else just doesn't come into it. You're not looking at individual cases. You're looking at it at a structural level and in quite objective terms. And that also explains why it's not relevant to consider how the UK funds its healthcare system or anything like that. I urge the court, when considering this point, just please go back to those passages which I've cited in my note where it does consider purpose, and it just says those passages only make sense on the assumption that if we add VAT to something, that increases, and that will increase the cost of medical care because of the sticking VAT status. So that is the level at which it pitches. It's quite an objective question. It doesn't relate to the facts of the case. It doesn't relate to the particular member state. If I may now turn to Horizon, if we go back please to paragraph 20, so it's tab 24. In fact, if we start at 18, so admittedly, as Horizon essentially submits, the transfer of knowledge and skills between a teacher and student is a particularly important element of an educational activity. But at 20 it says, as the Commission has submitted, the educational activity referred to in I consists of a combination of elements which include, along with those relating to the teacher-student relationship, also those which make up the organisational framework of the establishment concerned. So what it's doing here is it's saying that education in I includes not just the transfer of knowledge, but also this organisational framework. And that if you're only supplying a transfer of knowledge, that's all you're doing. Without this organisational framework, it's not education for the purposes of I. And so there's no read across from that, because as I said, there's absolutely no reference in any of the medical cases to a requirement for some sort of organisational framework. Indeed, as I said, when it was suggested in Peters, it was rejected. Instead, what you do see, and you've seen repeatedly, is simply a requirement for diagnosis and treatment. Not diagnosis and treatment in a particular organisational framework, just diagnosis and treatment. And that may have something, possibly a lot, to do with the structure of the education exemptions. If you could go, please, to tab 4. And look at I and J again. So the provision of education, including the supply of services closely related by bodies governed by public law, which have as their aim ... So that's the equivalent to RB, in the sense of a particular type of supply by bodies governed by public law. But in J, separately, it has tuition given privately by teachers in covering school or university education. Education has been given the meaning you've seen in Horizon, which requires that organisational framework, which makes actually quite a lot of sense, or at least some sense, in the context of I, which is concerned with bodies governed by public law having particular aims. But a different concept is used in J, and J would be the closest to C. And that just asks about tuition given privately by teachers covering school or university education. And there's no suggestion, indeed it wouldn't make very much sense to say that tuition in J had to have some sort of organisational dimension.
Yeah.
So there's, in my respectful submission, there's no read across from the way the court has interpreted education as requiring an organisational framework in I to C, in relation to medical care, where we've got no such reference, despite the court having many, many opportunities to say something like that if it was relevant.
Mm-hmm.
And then I think that brings me finally to fiscal neutrality, which I've already touched on, but it is relevant. So if it is the case that doctors going directly to the NHS and providing their medical services, which are then incorporated in the NHS, could be or are exempt from VAT, then it would be a breach of fiscal neutrality.
Well, you say fiscal neutrality, I think it was X, which refers to it in the context of competition. If you're looking at it from the demand side, from the NHS, if you've got two comparable services and one's 20-odd% cheaper than the other,
yes,
then there's no neutrality, you say.
Well, that's exactly it. That's exactly it. So, and my little friend keeps talking about this in terms of evidence, but with respect, you've seen repeatedly in the cases, the court relying on fiscal neutrality has never said, and we've seen evidence that proves this. It's never a question of evidence.
That's a structural. It's really about economic discrimination arising from the structure.
Exactly. And the question of whether self-employed locum doctors going directly to the NHS would be liable to VAT or not is a question of law. And you're assuming that the supplies are the same, or well, we're assuming that the basic elements of it will be the same because...
Well, your point is it's not evidence, it's a systemic issue.
It's a systemic issue, yes. It's a systemic issue. So if the same doc... I mean, it's very simple. The NHS has a choice. There's a doctor who can come to us directly and provide medical services during their shift, and we don't have to pay VAT. Or we can go to main pay through A&E. My learned friend says no points taken on the links in the chain, but go to main pay, get the same doctor or someone equally qualified, and I come and do the same thing. And if those two are different, are taxed differently, then you've got a breach of fiscal neutrality, and that's what the court repeatedly says we cannot have. Now, in my learned friend's case, and I made this point earlier, both will be liable to VAT. But that is instinctively wrong. If the doctor comes to the NHS and says, you need someone to treat your patients, I know how to treat your patients, I'm qualified, I'll do that shift and I'll diagnose and treat those patients. That is plainly supply of medical care. And I said the costs involved here could be very substantial because there's so much of this learning going on. But we say that's plainly a supply of medical care. So if it is right that main pay, on my learner friend's argument, would actually have to pay VAT on supplying a doctor to do exactly the same thing in exactly the same way, that would breach fiscal neutrality, which gives you a powerful reason to say that's not the right answer. And given that we say it's very clear that a doctor coming directly is providing medical services, and my learner friend seemed to waver a little bit on this because when he was talking about Peters and LUP, he was focusing on the fact that the person did have the expertise in their own right. But if that is exempt, and our submission it is, and that's a question of law, not a question of fact, which this court is my submission has to decide in the context of this fiscal neutrality argument, then there would be a breach of fiscal neutrality, and we've seen repeatedly the court doesn't countenance that. My lords, my lady, thank you very much for your attention. Unless I can be of further assistance, those are submissions and reply. I know, however, we're given homework.
Yes. So let's just remind ourselves. It's that word. I think it's paragraph 27 in Kugler.
Medical services are involved. Isn't that
Involved. It's the word involved.
Yes.
Yes, and then you were I had a look at that old case, Customs of
yes, the
Customs
nurses'
and Excise,
case.
as they were against Reed Personnel Services Limited. I haven't, I'm afraid, got the STC citation here, but it was a March 1995 case.
Mr. Singh.
Mr. Justice Law.
Yeah. I just checked something, my lady. Is that the same case it's referred to in a footnote by the upper tribunal?
It was.
So-
I thought the first tier tribunal went there. Actually, it's the one that talks. It's a. I'm quite old, as you know, Mr. Singh, but it's very familiar on the approach that you use. Usually, it's cited to do with whether the contracts are determinative of the VAT supply.
I think
but
it's
the
the
facts
one-
are quite interesting.
Yes, I think it may be the one. It's referred to on page 50 of the core bundle. It's a footnote to paragraph 95 of the upper tribunal's decision. I just want to check it's
That's
the same one.
STC 588. That's exactly the right one.
I see. Okay.
And I just thought on the facts there, I would be assisted by. You don't need to file any submissions if you don't want to, but a paragraph or two just saying, because as I read it, I mean, it is a little bit different because the rival arguments were on the one hand that it was a supply of nurses. Let me get it straight. HMRC was saying it was an exempt supply of medical care, i.e. the nurses that were being supplied. And the tribunal said, no, it's not. In fact, what it is agency services by Reed in the days when you looked at it as a sort of agent service. And I think the agency aspect has all been overtaken by Adecco and other cases that were in the bundle for today that we haven't had to look at. So it's not an exact parallel, but the point that I was interested in is that it does, as I reread it, I think I'm right in saying both the tribunal and the High Court confirmed that whatever this was, it was not a supply of medical care. And that's just, it's a lower court than this, so it doesn't bind us, but it's
And I
something.
think that in that case, Reed actually retained a high degree of control over the nurse's activity. So we would say,
Could you have a look at it? Because I don't think that's right, actually. Reed
Okay.
it was the hospital that had the power to direct the nurses.
I see. It's just that whilst I was listening to my learned friend's reply, I just had a quick look at the judgment.
Yeah.
And one of the findings seemed to be that Reed retained a high degree of control over their activities. These are the activities of the self-employed nurses. And then, as you say, milady, the commissioner's view was that they were supplying nursing services. The alternative view was that they'd acted as a recruitment agency supplying nursing staff, and the tribunal didn't just stop with the contracts, but looked kind of at everything, the overall view of the facts. So I can make a submission on it, my lady, as in if you would like me to, as in or
I think
overnight.
it might be fairer
I
to,
think
to
so.
leave it
Yes,
to
of
the
course.
appellant for you. I suppose there needs to be a sequential exchange.
Yeah.
You know, if there may not be very much to say about it. It was just one that was in mind. As I say, I'm old, Mr. Firth, so it just came to mind.
We'd like to deal with it all reasonably quickly. I think probably a short sequence of concise submissions. Do you want to start?
I'm happy to start.
How long do you need? And on questions of translation, you should be able to agree something. It shouldn't really be a matter of...
My lord, we actually had a quick look at this. I mean, bear in mind this is only Google Translate. But the German version of paragraph 27 apparently says it is sufficient that two conditions are met. The services must be medical services
Well,
and must be...
this is
This
what
is
we
precisely what
this is what we thought, but we'd like to get a bit of chapter and verse. And of course, you may want to look at any of the other 27, 28 languages. We'd be particularly interested in the Estonian version. But we'll leave that to you. We'll leave that to you. How long do you need? Just
How long would
look,
you
we're
like
really
us
not
to
looking
sit?
at any very long at all.
No, given that we're supposed to be sitting tomorrow, I can probably get this to my learned friend probably by lunchtime, to be honest.
What's tomorrow? Tomorrow's Friday, isn't it?
Yes.
By the end of the day, we'll give you that.
Thank you.
And Tuesday?
Yeah, it's fine for me.
If you're otherwise committed, the odd day is not going to
Yes.
trouble us, given the length of this litigation. See, we've worked out who's going to do the work.
So Tuesday's fine.
Well, thank you all very much indeed. We will reserve judgment. Judgment will, as you know, will be subject to the normal embargo, which will be on the front page, and as you know, that is now really quite strict. A breach of the embargo risks being a contempt of court. Edits only, not an opportunity to re-argue. We'd invite the parties to agree an order. If you're unable to agree, identify what is in dispute and we will resolve that on the papers. Can we thank everybody and those behind for very interesting, well-prepared written submissions. Thank you very much indeed.